Hello, you are listening to the COPcast from Shoesmiths with 3 COP lawyers. My name is Lauren. I'm an associate in the Court of Protection team.
I'm Rebecca Bristow. I'm a senior associate in the Court of Protection team.
And I'm Lucy Taylor, a principal associate in the Court of Protection team.
Welcome.
So we are back for episode 3.
Thanks for joining us.
Yeah, it's great to be here and really exciting. We're in our actual podcasting suite this time, which I don't know if any photographic evidence will ever be released, but I can tell you it's very colourful, it's very exciting and it's very techy, which I'm totally not used to, clearly. So we've had some feedback from the last couple of episodes, and touching on that, we thought we'd go back to basics a little bit with this one, didn't we? Because the whole intention of this was it was a bit of a kitchen chat, and we are conscious that we sometimes skip over phrases and we bound them about because we know what they mean, and we're conscious that maybe listeners you don't. So today we're going to start off right at the start for us with deputyships. We're going to have a chat about what they are, and we're going to try and do some busting of some myths that exist around what a deputy is, what a deputyship is. And it really goes back to episode 1, where we spent quite a lot of time talking about lasting powers of attorney and why they were important and how they helped you to plan for the future and ensure that you had the attorney that you wanted looking after your affairs when you can't. And so we're going right back to what happens if you can't make an LPA, and either that's because it's an unforeseen situation, such as, maybe you've been involved in an accident, you've lost capacity. What happens if you've had a stroke, or what happens actually if it's too early? So people who are born with brain injuries will never formulate capacity. People who've been born with a severe learning disability will never have capacity to make an LPA. And then at the opposite end of that scale, we've got people who, elderly clients who just haven't got round to it. So what happens then? Well, I mean, in a nutshell, it's called a deputyship, and that's where we're going today. So over to you guys. So Rebecca, what is a deputy?
So a deputy is somebody appointed by the court to make decisions on behalf of another individual.
Okay, and they can make decisions about a person's property and affairs as a property and affairs deputy.
Yeah, or health and welfare decisions if appointed for a specific decision.
Yeah, you can have blanket welfare orders, health and welfare deputyship orders, but they are quite
very rare
still, aren't they? Yeah. So is it possible that you could have a deputy and an attorney?
Feasibly, yes. It could be that somebody's got around to making provision about health and welfare or property and affairs, but hasn't done both. And so a deputy has to be appointed to step into their shoes for one or the other with.
Yeah, and I think it's probably more common that people do make the property and financial affairs LPAs these days, but don't necessarily deal with the welfare aspects. And if there are very complex welfare issues, then that could potentially end up in the Court of Protection.
Absolutely. I think it's important to remember that they are 2 separate documents. Power of attorney for property and affairs and power of attorney for health and welfare, and the court deal with them very separately.
Yeah, and I think in those situations, if you ever did end up with that, you would have to think very carefully as to whether the attorney or attorneys could work with the deputy and get that mix right, definitely. Because we do hear a lot of the terminology just bounded around, don't we?
Yeah, and you hear deputy, deputyship, attorney, attorneyship, and people use them interchangeably. And I think you need to be clear that a deputy is appointed by the court, an attorney is appointed by the individual, and you can only be a deputy once you've been given that authority in a court order.
Yeah, and the deputy only comes into play when the individual whose affairs we're talking about has lost capacity.
Yeah, you can only make a lasting power of attorney when the individual still has capacity. And if you're past that point, you no longer have that option, probably.
Yeah, so that's the fundamental crux of the difference between the two, isn't it? Incapacity.
The capacity
issue. The capacity issue.
Yeah. With that in mind then, what kind of situations arise where we might be thinking about whether a deputy's needed? Lauren, what are your thoughts on that?
I think it's a case of observing what's going on in somebody's life. And if you reach a point, the crux really is if somebody's starting to lose capacity, or if you've got suspicions that somebody's perhaps not functioning as well as they had previously. Your starting point will always be looking at capacity and whether it is or isn't there. Again, that's a whole other topic, and it's not a black and white issue.
Do you think sometimes it kind of, these things, in my experience, tend to fall into people's laps? Very rarely is there advanced planning when it comes to a deputyship. It tends to be a situation when a relative might go into hospital and sadly can't then go back to their home, and it transpires as a result of that they are now lacking capacity.
Exactly.
And a family member ends up in a situation then where they're having to make decisions and they don't have any authority to do so, is the long and short of it.
Almost overwhelmingly, the clients that come to us for this kind of thing, something has happened, something has changed in their life that means that family members around them, or it might be a local authority or somebody else, ends up having to reach out to someone like us to say, look, this is what's happened, we need some help here. And it's not always where somebody's got a lot of money. It can be multifaceted, if decisions need making in somebody's life, whether there's money there or not. And what is a financial and property decision is quite a broad spectrum. And like Rebecca said earlier, there's no a partner or a spouse or a parent doesn't automatically have the right to make those decisions or move funds around or do any of those things. So you can often find yourself at a loggerhead where a decision needs to be made. It transpires that you don't have that legal authority, and that's where the court becomes involved.
Yeah, I mean, I think if you're in that situation where you've got a relative who's lost capacity, naturally there are things that will need to be done. And quite often the sticking point is data protection, isn't it?
Absolutely.
So, for example, you ring up BT and you say, my relative's gone into care and I just want to close down their account. And they won't be able to discuss that with you. Or you want to cancel the utility bills. That's, a fairly minor sort of thing to be doing. We're not even at the stage where we're talking about, do we need to sell their property? Do we need to access cash in bank accounts? Do we need to cash in an investment to pay for their care? How do we pay for their care? You're not even at that stage. You've already hit that brick wall because you're just trying to close the phone account. So I always think that a deputyship is the key that unlocks data protection, because it gives authority to that individual to be able to make decisions and to actually do the act that you would otherwise be doing.
Absolutely. Interestingly, I find it's always those sort of more minor things, as you might put it, that end up being the most difficult ones to negotiate. BT, we are looking at you.
British Gas.
Okay, bad example. But it's anybody. Even ringing up to cancel someone's newspaper subscription.
Think about all the basic life admin.
You are not that individual, and you have to clear security whenever you call anybody. We all know that. We all do it, and we don't really even think about it because it's our personal information. And it's absolutely right that companies are doing that because they're keeping our personal information safe. And the deputyship order in this case is the kind of way to step beyond that, because you step into the shoes of the individual when you've got that deputyship order. That's what the order allows you to do. It
does really hold some weight as well, I'd say. It's a really court document tool that's sealed by the court, and I think as soon as people see that, they think, okay, this is
definitely enough. And I think you're right to say that it's not something that people should just be thinking, okay, well, this doesn't really apply to me because I haven't got very much money. If you have a bank account, full stop, whether it's got £50 in it or 5 million in it, you are the only person entitled to operate that account, nobody else. And your next of kin or your spouse or your husband, wife, siblings, whoever they are, they're not going to be able to access that account. And
everything has a paper trail these days, doesn't it? If you've got a mobile phone, you've got a mobile phone contract.
Absolutely.
If you have a car, you buy a car on finance, any of those things, like lots of things can happen on a daily basis that involve you having to make agreements or agreeing contracts that you don't think you're making, or agreeing contracts, but it does involve that.
Yeah, definitely. I mean, we've touched on it a little bit, but what does a deputy do then, Becca? What?
I always think the best way to describe this is if you think of a concierge service. So anything that that individual needs to do with their life, which covers their property affairs in any way, shape or form. As Lauren was saying, it can be as basic as a utility bill up to having to sell their home with the relevant authority. A deputy can do. And that means the role of a deputy is extremely varied. So one day you could be negotiating for a care home placement and care home fees and how that's going to be funded. And the next day you could be simply trying to close a BT account. It can go so far as when you have more complex matters, managing a care team, employing staff for an individual. So it covers the whole spectrum because, as you said, you put yourself into the position of that individual and do everything that they can't make a decision for themselves.
Anything that might normally happen in somebody's day-to-day life.
Yeah.
So you both act on behalf of deputies and support deputies with that role, as do I. What things have you done this week? So I this morning have been negotiating with the local authority over direct payments to pay for my client's care. So without the deputyship order, we wouldn't have been able to do that. We wouldn't have had authority to do that. So that's something I've done. What have you both been up to?
I would say anything that needs paying for, we can end up getting involved in. So this week in particular, I've had a disaster with a boiler, and you think, you don't necessarily assume that your lawyer will be dealing with boiler negotiations for you, but it's just been an absolute nightmare, and there's contracts involved and money will be changing hands and it's going to cost money. So I'm getting involved in it. I can be an advocate for that client. If it needs doing, it needs doing.
God, we sound really exciting, don't we? Boilers and direct payments. We're living the dream.
Shall I make it slightly more interesting?
Please do that.
So yesterday I was liaising with a criminal solicitor supporting my client who's on trial for a criminal offence that he may or may not have been guilty of. But that involved liaising with the solicitor, liaising with his case manager to make sure that he was supported to attend the hearing. It was also involved supporting the case by looking at his psychiatric history, so liaising with doctors who we've instructed previously to give him support in terms of his depression. So that's
more the welfare side of it as well, isn't it?
It is, but when you make that, if you break that down into the more fundamental side of things, I organised a taxi for him to get to court. I organised for somebody to attend with him. So I paid the bill for that person to attend with him. I supported getting legal aid for him so that he had representation at the hearing. So yes, it all sounds like it's welfare related and it's really exciting in a slightly off the wall, slightly different from a boiler case. But fundamentally, that was transactional and dealing with those elements of it.
Lots of welfare issues require somebody to be paid, ultimately.
Yes, and that's where the crossover comes a lot of the time, isn't it?
Exactly. We're not necessarily advising on what intervention they might need for somebody's welfare or health, but if it's known to be needed, we can go about organising that.
Yeah, there's definitely a crossover, and it's something that the Court of Protection have been very alive to, that, you know, you can't just be a deputy looking after somebody's money in isolation of the welfare issues, which is something you touched on earlier, Rebecca. Lauren, so if you are thinking, or you know, if the situation presents where a relative has lost capacity, or maybe you have, you know, a parent and there are 5 or 6 brothers and sisters in the family, and somebody is saying, well, someone needs to do it. Come on, you know, who's going to do this?
Who volunteers as tribute?
Yeah. What advice can we give to people who are, you know, in that situation? They're either thinking that, oh God, I might need to become a deputy here, or actually I feel a moral obligation to become a deputy here.
Yeah, I think that follows on quite well from what we've just been discussing as well. It's, you know, you might think that it's very easy when somebody asks you, or can you be my attorney, or you know, can you be so-and-so's deputy? You think it might be quite a straightforward paper exercise, but it is all-consuming and comprehensive. And if somebody asks you to do it, you need to be considering how that's going to impact your life, whether you are an appropriate person, and whether you're going to be able to give it the time and care that it needs.
Who can be a deputy?
In theory, anyone, but
over the age of 18.
Over the age of 18, but there are also caveats. So
and presumably you have to have mental capacity yourself.
Well, exactly. That's a good point. Also, there's things like if you've ever been bankrupt, or if you've got any records that would raise concerns about your ability to act. So those things will rule you out. It's worth noting.
That's really interesting because, and I've got to reference this here because eagle-eyed ones that were watching EastEnders might have noticed this week that Sonia reappeared on the scene and announced that she had been made Dot Cotton's power of attorney. And okay, it's slightly different because it's an attorneyship and not a deputyship, but the same principle applies. And I'm sure that Sonia had stolen money from Dot. And I don't necessarily think that she ended up with a criminal conviction. But, I mean, yeah, if you are not great at managing money, or if you
Absolutely.
are, but because the individual can't say, well, Dot, presumably, I'm going to assume Dot hasn't got capacity for now. And I'm going to say, well, Dot's lost capacity. If that were an individual who's lost capacity, anybody can be the deputy. How do we ensure that the proposed deputy isn't somebody who's stolen money, or how does that work?
This is the thing, I think. So I suppose what's different about a deputy as opposed to an attorney, the fundamental difference is there are so many more regulations, and there's a lot more accountability there for that person who's acting in that role. So firstly, the court has to decide whether you are an appropriate person.
So it's the court that decides, not necessarily me or my brother or sister.
You can have a discussion and work out who might be appropriate, but ultimately you would have to make an application and the court would ultimately decide. But also you want to be thinking about whether you want to be put forward for something like that before that application even gets made. So if you already struggle, like you say, Lucy, if you already struggle with sort of life admin tasks, even though most of us all find those probably a little bit annoying, if you already struggle to keep on top of your own, you're probably not an ideal person to be a deputy. You're going to have to be doing things like filling in accounts, reporting to the court. You have to take out a security bond, which is sort of like an insurance policy.
Yeah, I mean, can you imagine? I mean, if most of our husbands actually were put in a situation where they had to do these things, if they ever had to become our deputies, I'm not sure mine would cope. I'm not sure he would even know the basics of financial management.
That's really important when you're considering whether or not you do want to be appointed, isn't it? Because this is a purely legal role you're taking on. So, and you are responsible for somebody's finances and reporting to the court essentially for what you're doing. It's not a caring role, so you're not considered a carer. And it's, if you think about how much goes into running your own day-to-day life and the amount of time it takes to deal with your own life admin, if you like, you're doing that for two people and you don't get paid for it. So as an individual acting as a lay deputy, as you'd be coined, you can't charge that person for what you're doing. And
it will be time consuming.
It's almost like a second job.
It is, exactly. Yeah. I mean, we literally do it as a job.
It's
so
a day job.
This tells you how...
we don't just do it for one person, but yeah, it's really time consuming. I have to say that I don't know why anybody would ever choose to be a lay deputy. I mean, I'm an only child, and I think there is that feeling that, oh God, it's a burden and I have to do it because of that moral obligation. Because if I don't do it, who else is going to do it? I mean, there are other options, aren't there?
This is true. I mean, we have a job and are talking to you here today. So there are people like us about who can do things for you. And a lot of people come to us and they think, I'm not against the idea of doing this for my parent or for my sibling. They just acknowledge that it's an all-consuming piece of work, and if they're not going to get paid for it, and it is going to take up an awful lot of time, it might not necessarily just be a case of, well, I'm not doing it if I'm not getting paid for it. It might just be a case of, I don't have the time to commit to this, and I don't trust myself to do the best job that needs to be done for this person.
I think that's absolutely right. And I think, in the context of the person's affairs that you would be looking after, you would be managing is the right word.
Yeah, you're like a project manager for that person.
You have to be competent. That's really key. And you have to look at this as almost like a competency based question, because you're sort of saying, okay, this person has these assets, do I know what I'm doing? Do I have the right skill set? It's no good kind of never having managed financial affairs or having very limited exposure,
exactly,
and then agreeing to manage somebody's affairs who might be a business owner who might have investment portfolios, even investment properties. Okay, you can seek advice and guidance and professional services. And I think that's really key for anybody becoming a deputy and they recognise that they want to do it but they need help. There is obviously the ability to do that, but you have to have a basic level of understanding if you're going to enter into those
and you don't
situations.
always know what you're letting yourself in for. When somebody asks you to be a deputy, we get this all the time. If we get a referral from a local authority, for instance, we say, this is this person's name and this is their date of birth, here you are their deputy. And it's just like, oh, okay, what do we do now? And you can it's like opening up a Pandora's box. You discover all this. I think we mentioned this in one of the previous episodes. It's like you're opening up somebody's entire life. And even if you're somebody's child, I know, for instance, if I was my dad's deputy, for instance, he's got his fingers in all sorts of pies. He loves that stuff and he's very secretive about it. So if ever the day came, I'd be completely inundated and it would be absolute chaos.
But you tend to find that we get quite a lot of applications or referrals from existing attorneys, don't we, where something untoward has happened
and deputies as well.
Because
I don't think any I have to have good faith in humanity and say that I don't think anybody who starts off thinking about being a deputy and even being appointed as a deputy or an attorney does so with the intention of doing a bad job.
No.
But it's purely a lot of the time that they just don't understand what it entails, what it involves, the extent of it. And that's where a lot of deputyships, they just don't quite go to plan. And unfortunately, in a lot of cases, that can result in financial loss for the individual because they haven't quite been dealt with properly. So there is that. So I mean, God, we're not making it sound very attractive, are we? I mean, deputies have a hugely powerful role to play in supporting people and making decisions for people where they can't, where they've lost capacity to do so. It's a really responsible role, we've heard that, but there must be some form of accountability and supervision. I mean... Yeah,
there absolutely is. So that's the difference. One of the key differences, as Lauren touched on, between being an attorney and being a deputy is that for everything we've said about it being really important for you to put your thoughts, wishes and feelings in place and to enter into a power of attorney, attorneys aren't supervised in the same way that deputies are. So deputies are supervised by the court's supervisory body, the Office of the Public Guardian. I think the way I've explained this to clients before is you literally have to account for every penny in and every penny out.
Quite rightly so as well. It's someone else's money.
Yeah. So you have to provide accounts to the Office of the Public Guardian every year to show what you've been doing, how you've made decisions, where money's come from and gone. And if there is a question, if something doesn't add up, you will be asked to explain what's happened. You will be pulled to account. And that's where the surety bond sometimes comes into play, where there has been some, unfortunately, it does happen where a deputy's acted not in favour of the individual and they've had a financial loss, and the surety bond can be called upon where it's been proved that there's been some fraudulent action or untoward action.
It's also what a deputy doesn't do. So, I mean, you're expected to have, access to benefit information, benefit knowledge almost as well.
This is because something that's often missed, isn't it?
The OPG, will go through the accounts and they'll look at, what money's come in, what money's gone out, how it's been spent. But they'll also go on a deeper level. The OPG will expect you to be looking at where a client's money is. Is it safe? Is it in the right place? How is that investment doing?
It's the active management side of it,
isn't it?
Absolutely.
Are they receiving the right benefits? Obviously, there's a further issue there if somebody is not receiving the right benefits, and they may have been receiving benefits to which they're not entitled to for a number of years. But as a deputy, if you then don't identify that and deal with that moving forward, that's an issue.
Absolutely.
So it's not just the accounting aspect; it's the management. It's the management aspect, and it's not passive. You have to be active in the role, and the OPG will ask you questions in the report to gather that information. For example, if somebody has got a house and they've gone into care and they may be funding their care from elsewhere, from other means, from other cash, what's happening to the house?
It's
making sure that that's not just a deteriorating asset.
Also, even something like your insurance may not even cover the property anymore if it's empty.
Because it's unoccupied.
Yeah.
So it is very much about that active management, and the supervision from the OPG is there to support deputies, but very much helping to support them to do an active job.
Yeah, it's an encouragement, isn't it, rather than a punishment, I would say.
Absolutely.
I suppose that's a key difference between deputyships and attorneys, again, in that you don't have those same checks and balances in place for lasting powers of attorney. You don't have, well, the key thing is the security bond, really. You don't have that quite literal insurance policy for a lasting power of attorney that means if something does go wrong with something like that,
I mean, there is a bond that's come to market that may assist in those situations.
I do think that's a good idea, actually.
But it's certainly not, as well, it's not mandatory in the same way that it is for a deputy.
Probably not widely known about for lay people.
We can take out a bond. Well, we have to, don't we? We have to take out a bond for any deputyship. The deputy has to maintain a security or security. It's all interchangeable. Again, it's that use of language in our field. But they have to take out a bond. And it is it is an insurance premium. And essentially, if a deputy doesn't quite get it right or defaults and there's potential financial loss sustained, then the bond, a lot of people think that the bond will pay out to reimburse people the total loss. And that may be the case in terms of the amount that's paid out. But usually the purpose of the bond is to essentially provide that individual with a couple of years worth of shortfall between their income and expenditure so that the loss that's been sustained can be investigated. Now, in practice, when the bond is called in, it can be called in up to the maximum amount, but whoever's calling in the bond and working with the public guardian to do so has to demonstrate that there's a clear loss and has to demonstrate how that loss has occurred. And it might be that by the time the bond is paid out, it does actually reinstate the loss, but actually that isn't the purpose of the bond. It is only to cover that shortfall so that the loss can be investigated and
buys you time, really,
and recovered,
I suppose.
Directly from that deputy who has defaulted. So it can be a valuable source of sort of insurance. It's a fallback, which isn't there on attorneyships.
But it's something which is being investigated on attorneyships, isn't it, with this attorney bond that has started to creep into the market. I think there's quite an appetite for it because it would provide that extra level of insurance and a bit more peace of mind, I think, if you are entering into a power of attorney.
Yeah, I mean, what about Senior Judge Lush's comments a few years ago?
Yeah, he was keen to make it clear that he wouldn't be happy to have an LPA. He would much rather have the oversight of the court and that insurance which is provided when you have a deputy. And there is a lot of merit to that.
Yeah, he was pretty certain in his position, wasn't he? I think he said he categorically would not have a lasting power of attorney.
You can kind of see why, can't you? With an LPA, okay, the greatest thing that it gives is flexibility whilst you've got capacity, and it gives choice.
Yeah.
But equally, you don't now have to notify anybody when it's registered.
I think there's also the problem as well that they are so accessible that if you are drafting one yourself,
very easy to get wrong.
Very easy to get wrong, and then it's not usable in the way that you wanted it to be at all. You appoint both your children jointly. One of them dies, unfortunately and unexpectedly. You've lost capacity. You can no longer have your daughter acting for you anymore.
I think that's probably why Judge Lush came to the conclusions he did. I hate to be a Debbie Downer again about the nature of our day-to-day work, but I suppose if you're used to seeing the fallout of this all the time, that probably makes you a bit more cautious.
Yeah, and I think I'd be more comfortable if somebody were managing my affairs and I knew that they had to report every year to a statutory body who would then look at how my affairs have been managed. I'd be comforted by that. So. But equally, the risk that you run with that is that you don't know who your deputy is going to be.
This is true.
We've said, anybody can be a deputy, pretty much, over the age of 18, having capacity. Yeah. There are some restrictions around, whether or not you would get a security bond if you were made a bankrupt, etc. But, by large, anybody. Is there anything that... Can you do a letter of wishes that says, specifically don't want an LPA. I'm not going to make one because I'm not comfortable with the lack of reporting and accountability and supervision necessarily around it. And if anything happens, I know that I'll need a deputy, and I'd like Bob, poor Bob.
Yeah, you absolutely can. It's not binding, unfortunately, much like any letter of wishes isn't binding, but that ties in, doesn't it, with having those conversations with your family and your friends ahead of time, making it clear to them, I would like you to do this for me if I'm no longer able to make the decisions myself, and I don't want to have a power of attorney for these reasons. Which will then mean that the conversation can have been had with with people who are going to be told about the application, so that everybody's happy with it before it gets to the court, and
it doesn't come to as a shock to anyone.
Yeah,
perhaps. Yeah. I mean, I think as British people, we're very inclined to not talk about things quite a lot of the time, and I think probably one of our key takeaways from doing this is that it generally benefits people for this to be talked about more openly, more often.
We keep banging on about this, don't we? We just need to not be so closed. Yeah, we need to be more of an open book about what we want. Okay. So how do you become a deputy? How does it work? How do you get a deputyship? How do you do it?
In short, it's an application to the court. It's a paper application. A bit more complex than the lasting power of attorney documents, unfortunately. You do have to fill in a lot of forms and provide witness statements and things like that. Probably a good idea to seek some advice if it's something you're looking to do.
Do you need to know about the person? Do you need to know what assets they've got?
Ideally, yes. You can make an application without certain information, but it would make it less likely that it would go through, I imagine. A lot of the time, if a local authority is making an application, it's a bit different. But if you're applying on behalf of somebody, you essentially want to provide the court with as much information as you can to ensure that they are able to make a decision with all the relevant information. So you want to be, when we fill out these forms, we're providing full and comprehensive information about somebody's finance, income streams, outgoing expenditure, capital assets, savings, investments, interested parties. You need to know as much as you can about that person, because the court doesn't make these decisions lightly. They are ultimately restricting somebody's freedoms by doing this. So they need to be sure that all the information there is right to proceed.
I think it's fair to say the court are also looking at competency to
Absolutely.
a degree as well, aren't they? If the court sees an application form which, somebody has a very complex estate or maybe even a complex family arrangement, they're going to want some reassurance that the individual that they're potentially going to order be appointed is able to do the job.
It's worth saying that the potential deputy does need to provide information about themselves as well.
Yeah.
Quite a lot of information, actually. It can be quite invasive. But again, the court needs to be satisfied that you're an appropriate person.
Yeah, it's and so paper application, fill in the forms and send it to the court, and is that it?
We've missed a crucial point there, actually, I should mention. The key difference, one of the key differences between a deputyship and a power of attorney is that a deputyship can only be sought after somebody's lost capacity. So the key decision, you shouldn't be going anywhere with this until you know whether somebody has lost capacity. So that's your first point of call, really. You need to be getting a formal capacity assessment, and it's not a case of, Mrs. Smith next door has known so-and-so for a few years. Can we just get her to do an assessment? You need to get a formal.
That's perfectly possible on an LPA, isn't it? Mrs. Smith next door can say that I've got capacity to grant the lasting power of attorney.
Well, exactly that. That's one of the options, isn't it? If you've known somebody for 2 years, can you ask this person these questions and agree that they've got capacity?
I've never really thought of it like that, but actually, you've just put that in my mind. But that's absolutely.
It's good. What we're concluding, I think, here is accidentally that LPAs are maybe rubbish and that we should all have deputyship instead.
We would say that, wouldn't we? We would say that.
It's probably fair at this point to point out that if you make the application on Monday, you're not going to have the order by Friday.
This is a good point.
The court is...
Is that this year? or next year?
Maybe next year.
The year after?
I think the average turnaround time for a cause protection deputyship application at the moment is 26 weeks. Roughly.
And bearing in mind, that's when you submit it.
Yeah.
So it's quite a complex application. It takes time to put it together.
Yeah.
And also you've got to get a capacity assessment. That takes time. And when it comes out the other end, when you've got the order, it's not a case of you post it off to HSB in Halifax and, by the end of the week, you've got all the cash. It's far from it. I wish, but...
I have to say that in all of my years of practicing, and that's only a few, obviously, I have probably only ever seen an application go through in the sort of 20 odd weeks on a handful of occasions.
I was going to say,
I mean, I think it's really
that.
salient to point out at the moment that we have and we are still living through an international pandemic. And, as much as many of us have ended up working from home, as have the court staff, it is still paper-based.
Yeah.
They are battling with resource issues, working
like any
from
public
home,
body,
like all of us, and any public body is at, on the constraints of that even more so. So, I think 26 weeks. I think that's ambitious.
Optimistic.
Yeah, I think that's optimistic, ambitious. Yeah, definitely. I think you've really got to bear that in mind, because we do get the inquiries where people have that, I'm going to say it's typical situation, because it is very common. Somebody has become ill, they've gone into hospital, weeks have passed, they're discharged from hospital into a care home, and quite often, because there is something called the property disregard in place, there isn't quite as much pressure in terms of having to pay for care fees necessarily, or larger sums for care fees, and family pop their head in the sand. They don't want to think about it. They don't want to deal with it. And often they don't know what to do. And before you know it, 4 or 5 months have passed and we get the call to say, I've got to pay my mum's care fees. How do I get access to her money? Or how do I sell the house? I've been told I've got to sell the house. We've lost a window of opportunity of time there, and we could be at the back end of the deputyship application, and actually we're only just starting. And nothing can be done, can it? So until we get the order.
You mean in terms of what somebody's allowed to do without one?
Yeah. I mean, so in that situation, you can't sell the house, you can't access the bank account.
Nobody has that authority.
Can't do anything.
And selling the house, it's probably worth noting as well that that's not always a general authority that the court will give a deputy. So if there is even a whisper of that being something which you're going to have to think about as a deputy, you need to be thinking about that when you make the application. So at the start of the 26-week process, the court is aware that you might need to sell a house instead of you remembering at the end.
Yeah, definitely. Yeah. And also, if there's any suggestion, perhaps if that individual, and in most cases, that individual will be deprived of their liberty, if there is any suggestion that is being challenged and that individual wishes to potentially move back home, that will extend things, because there was a big piece of work there to be done in terms of looking at whether or not keeping somebody in a residential care home or nursing home is the least restrictive option. So don't automatically assume, I think, in cases where somebody has gone maybe from hospital to care or gone straight into care, that's where they're going to be and it's a done deal that you just need to sell the home to pay the care fees. It's about making sure that that person's gone to the right environment for them. And actually there's a bigger piece of welfare work there, which you could end up in further court proceedings. So you may not automatically get that order for sale. It can get very complicated. So timing's absolutely key.
Absolutely. Also, the Court of Protection's key focus is they exclusively look after vulnerable people. So they do not rush these decisions. When we're talking about restricting somebody's liberty, if somebody is not able to make their own voice heard, there is extra care and extra caution taken to ensure that the right decisions are being made. And that does take time.
And isn't that really reassuring that, if we're making these applications, which have such magnitude for an individual, we want to think that the court who are looking at the end process and who are making the final decision are doing so properly and thoroughly.
Absolutely.
And we've assumed as well that the application will proceed because it's not gone contentious. We love that, don't we? we love the challenge of a contentious application.
It's juicy.
There we go. So when you do make the application, you have to notify at least 3 people when you make any application. Doesn't matter what it's for. It could be very straightforward. I say straightforward in quotation marks because the nature of this job is never really that straightforward. But, you know, you've got potentially 3 or more people being notified of an application that is going to affect a lot of people's lives. And that can often rub people up the wrong way. Sometimes necessarily, and it's important that be questioned, sometimes unnecessarily, but either way you have to go through the process.
Yeah, and I think that's why, you know, going back to that question of if you're asked or, you know, if you're thinking of becoming a deputy, really do give thought to that, because you've got to think about, you know, if there are perhaps, you know, family relations are a bit fraught.
Absolutely.
You know, are you the right person to be applying? You know, is your brother in Canada who you haven't seen for 25 years going to come and say, no, not happy with that? You've got to give consideration to, would anybody object?
Involved.
You know, who would everybody be comfortable and happy with this? And I always think it's better to have those conversations up front.
Definitely.
Absolutely.
Rather than
time
just
in the long
somebody
run.
open the post one morning and there's this letter saying, oh, you've been notified that I've applied to be so-and-so's deputy. Yeah. Interesting. So I suppose that's a whistle-stop tour through our thoughts on deputyships. What are our what can we do as takeaway points? Are there some takeaway points that we can give people listening who find themselves in this situation?
Yeah, I suppose my takeaway from this one was that myth buster and the misconception that you will have authority to look after your loved one's affairs purely by being their next of kin or their husband or wife, and that's just simply not true. And you need to realise that to have legal authority to act for somebody else, you either need to be in the position of an attorney or appointed by the court. And that's really relevant not only in terms of spouses, but also for parents who've got children who perhaps they have sustained a brain injury at birth or in their early years, and you've been looking after them and dealing with their affairs as they're your child. As they reach 18, that authority as a parent ceases, and you need to give consideration as to how you're going to carry on in that role post 18, which I think actually opens up a can of worms into a completely different podcast.
Next time, or maybe not next time, but maybe the time after. Yeah, definitely. There's a whole kind of transitioning from childhood through to adulthood and managing.
Absolutely.
Yeah, brilliant. Thanks, Lauren.
I would just really press how big a job it is to be a deputy, is what I'd say. It's all-consuming,
We obviously
comprehensive.
did something terrible in a former life. Which is
I always say this. I hate doing my own life admin, and yet here I am doing it for a job for other people. But
yeah, it's a big pair of shoes to
it is.
to fill,
So
isn't
don't
it?
take it on lightly.
Absolutely. I think from my point of view, it's timing. You know, if you are in a situation where a family member is losing capacity, it may not be too late. So jump on it straight away, do something about it, because they may still be able to do that lasting power of attorney. But if they're not, actually get the ball rolling with your deputyship application. If one's needed, you know, if it's concluded that you need one, because the timescales involved are very long and horrific, and there's an awful lot that needs to be done, and you simply can't do it until you've got that order.
Absolutely.
Yep.
Just a little disclaimer for you all. This is not a substitute for proper legal advice. And if you have got any queries about anything or want to explore anything further, this has been informal for you for information, but by all means reach out to somebody professionally for their assistance. Right, thank you for listening to episode 3 of the COPcast. You've been listening to Lucy Taylor, Rebecca Bristow and Dawn Miner at She Smiths in the Quarter Protection team. We hope you enjoyed today's episode, and we'd love to see you, hear you again next time. Thank you.